continue our work. Dear colleagues, candidate and the public, today on the 29th of March 2026, the advisory group of experts gathered in full to conduct an interview with the candidate for the position of judge of the Constitutional Court of Ukraine, Siur Nataliia Viktorivna. In particular, all 6 members of the AG are present. AG members Salar Zarar, Vasil Shakun, Yaroslav Romaniuk, members of the AG Hanna Sukhotska, Secretary of the AG Marina Connor, and me, the chair Oksana Vasilchenko. Also present at the interview are deputy members of the AG Vitaly Makhinchuk, Richard Barrett, Vladimir Kuzmenko, Marek Zubik, Thomas Griffith. I'd like to remind you that we work in a shelter, so in case of an air raid alert, the interview will continue uninterrupted. I'd also like to remind you that interview is being recorded and broadcast live on the AG Resources and the CCU website. Therefore, I draw the attention of the AG members and the candidate about the restriction of the use of sensitive data and information with limited access on live broadcast. If necessary, the AG will limit the broadcast for this time. We are ready to begin, so I give the floor to the Secretary of the AG, Marina Connor, to introduce the candidate and remind us of the rules for the interview. Marina, over to you.
Thank you, Madam Chair. Dear greetings, dear colleagues, and everyone who is watching. As our chair has already said, the advisory group of experts will now interview candidates. This candidate, Nataliia Siur. Let me remind you that the interview is a mandatory stage of evaluating candidates as part of the assessing their compliance with the criterion of high moral qualities. One interview should last no more than 1 hour, and the time limit for answering the questions is up to 3 minutes. Traditionally, we ask all candidates to be concise, to answer the questions posed clearly, unambiguously, and to the point. At the end of the interview, the candidate can make a short closing statement of no more than 5 minutes. I would also like to note that during the processing of materials about this candidate, the AGE sent her questions for written explanations, so the candidate had the opportunity to prepare and to provide answers. On November 12, 2025, the candidate submitted an application of intention to participate in the competitive selection for candidates for the position of judge of the Constitutional Court of Ukraine, announced on October 14, 2025 by the staff of the Rada of Ukraine. We emphasize that the advisory group of experts carries out its activities in accordance with the Constitution, the law of Ukraine on the Constitutional Court of Ukraine, the regulation on the advisory group of experts, and the evaluation methodologies, which are in the public domain and can be consulted by any interested person. In addition to the initial stage of the assessment, according to the criterion of high moral qualities, the advisory group asked you to provide written confirmation of the fact of familiarization with the regulations and the methodology. By letter dated January 27, 2026, you confirm that you have read the relevant documents. In the process of processing the materials regarding your candidacy, the advisory group has repeatedly sent you requests for written explanations in order to provide an opportunity for you to provide answers that could refute the existing doubts or conversely confirm a compliance with the established criteria. At the same time, you have not fully or partially responded to the requests of the advisory group of experts dated January 19th, February 11th, and March 5th of 2026. Despite the fact that both the initial general request and the subsequent rounds of questions contained a requirement to provide complete and comprehensive information in order to ensure the transparency and effectiveness of the procedure for evaluating candidates, in particular regarding to the establishment of compliance with the criterion of high moral qualities. The advisory group of experts separately emphasizes that since the beginning of its activities, it has encountered a case of such it has encountered a case of such a level of inappropriate interaction of the candidate in the assessment process. In this regard, in accordance with Part 5 of Article 2 of the Methodology for Assessing Moral Qualities and Level of Confidence in the Field of Law, which you have familiarized yourself with, the advisory group will take into account the fact of lack of cooperation during the evaluation process. Therefore, in order to ensure the completeness of the assessment, the advisory group will re-ask you questions to which you did not provide answers on the merits, as well as additional questions. At the same time, we would like to inform you that in accordance with paragraph 8 of Article 7 of the methodology, you are not entitled to provide additional information, documents, or other materials during the interview if such were requested earlier, but not submitted to you within the established period. Note that you have had enough time to submit documents that you consider relevant. So now we have with us the candidate for the position of Judge of the Constitutional Court of Ukraine. She is a practicing lawyer, and at different times she has held scientific and pedagogical positions in higher education institutions. In particular, Associate Professor of the Department of General Legal Discipline of the Donetsk State University of Internal Affairs, Associate Professor of the Department of Jurisprudence of the Central Ukrainian Institute of the Interregional Academy of Personnel Management, Associate Professor of the Department of Jurisprudence of the Kirovrad State Pedagogical University, named after Vinichenko. Since November of 2025, she has been a candidate and holds the position of Associate Professor of the Department of Law of the private higher educational institution, the University of Modern Knowledge. In May of 2026, the candidate defended her dissertation on the topic Legal Integration of Ukraine into the European Union, Theoretical and Legal Research, and received the degree of Candidate of Legal Sciences. I will now ask you if the candidate has any additional information to relay.
Так, дякую.
Yes, thank you. I'd like to say that academic work is not my primary activity. I consider myself to be a professional lawyer, and it will have been 30 years this autumn since I got my lawyer's license. I work as a practicing lawyer since 1991. After I completed my maternity leave, I gave a birth when I was a first-year student, and I was doing my correspondence course in the only legal educational establishment. I went through the selection procedure. It was a very serious selection, 26 persons per one student's position, and I have been able to succeed to that time. I thank the God and my parents that I was born in Ukraine, and I became the witness of the times when even when we were about to enter the university, it was checked how we were dressed, whether we have some symbols of the Soviet Union in our attire. And when I was studying in 1989, finally the state was transformed, and for me, the fact that I that I was able to get into law school as a woman, it was impossible for me without being a part of Komsomol and the Communist Party. Those were the times, and people of my age and a little bit older who are present here, without being a part of the Communist Party, you were not able to get into the law school. I was able to study in one of the most respectable and reputable university. It was the Kharkiv University of Law. It was the time of transformation, and when I started working as a lawyer. It was very difficult to work because the same legal relations were governed by the Criminal Code of Ukraine, where the entrepreneurial activity was considered to be a crime, and there was a law on entrepreneurial activity where it said that it was legal, and those were trying times up until 1996. And when I got my lawyer's license, the constitution that is now in force was actually finally enforced. It was a pleasure to work in those times. It was difficult to work in those times because they say it was the 90s, and then when the state was coming into being and making its first steps, but the constitution was in force. And in the law enforcement agencies, there were law enforcement officers. In courts, there were judges who really were addressed as your honor and were respected. But right now, it has been some horrible times, some transformational times. I don't think that we should blame someone personally. I'll not say that I stopped being a lecturer when the person who was convicted was the president of Ukraine, and I could not explain how come when I was lecturing what I had been imbibed with. I think that I'm fortunate to meet people who shared with me their knowledge and their values. So at some point in the beginning, there were some times when in my practice of law, because of my professional activity, I was persecuted, and up until Yanukovych times and after Yanukovych times and after and all the persecutions that I felt as a lawyer, the most difficult it was when Kuchma was the president.
Then in Yanukovych time, the law started functioning better, but then at some point in time, on the day of Ukrainian Constitution, on the 28th of June, my home was taken by assault. I did my best to protect myself in court. It was not about monetary issues. It was about protecting my personal dignity and my right to practice law.
Після того, як я отримала
After I received the questions from the AGE, I will explain. I will provide now more explanations regarding the requests from the AGE. I do not agree that I failed to display due diligence.
як професіонала.
Let me remind you that it is supposed to be a speech supplementing your self-presentation. Yes, I see the point. I just would like to make a point that it has never been that difficult to me to exercise my professional activities. Unfortunately, the advocates community in Ukraine is completely disintegrated. The Ukrainian National Bar Association is does not contribute to the consolidation of the profession. They only deal with continuous training issues while remaining quite limited in terms of their contribution to other areas of life. So I am here because I want to contribute to the operation of the Constitutional Court of Ukraine, because I don't want to stay aside and witness Ukraine turning into a young dictatorship, yet another dictatorship. I want my country to be a democratic one. And by the way, speaking of dictatorship, it's not only my opinion. I'm looking at the situation in the neighboring aggressor country, where everything started with the Constitutional Court. Ms. Siur, thank you very much. Thank you for making all of your points, but let me remind you that our goal here is to assess and conduct your check of your candidature against the criteria of high moral qualities. So I'm handing it over to Ms. Hanna Suchocka at this point.
There's always a problem with I got my voice. Just a second, I have problems with voice. Do you hear me? Yes, because I had some problems.
Якщо ви не заперечуєте, я
Yes, now you can hear me.
Так, я чую вас.
Good. Yes?
Так.
Yes.
So now, Ms. Siur, I would like to give you some questions, because our role today is to ask you on some issues which are not very clear for us. Some mistakes in declaration. First question. According to the declaration submitted by you for the period from 2018 to 2024, on March 11, 2010, you received a lease of a land plot with a total area 514 quadrat meter in the city of Kropyvnytsky. The owner of this plot is the city council of the city of Kropyvnytsky. Please explain the circumstances and purpose of obtaining a land plot for lease. Why did you not provide an answer to this question before? Why did they not provide documents confirming the occurrence of the lease right? It is a first question to you.
Я розумію.
I understand that Constitutional Court justices and candidates to the Constitutional Court are supposed to comply with the criteria of integrity. However, I am a practicing lawyer now. I have sufficient income now. I pay taxes as a self-employed person, as an entrepreneur. Since I've been combining several activities, and all the members of my family, my deceased parents, my husband, my children are employed. I consider myself to be a successful person, so I didn't provide the document requested on purpose. I inherited considerable assets from my deceased parents, from my deceased husband, and since it's not only me who is indicated in the document about inheritance, I decided not to, but also other persons, I decided not to provide them on purpose. Speaking of the land plot, when we bought a house, the legislation didn't provide for the privatization of the land plot on which it was located. But then the legislation changed, and the law so the law changed, and the city council ruled that having a lease contract was mandatory. So we bought that apartment. We repaired it, we reconstructed it, and then after the legislation changed, it turned out that we should have either register the right of ownership or the right of lease. Since at the moment where the legislation changed, the house was already rebuilt, repaired, and our family would dwell there, so we had to make this additional arrangements in order to officially register our right of lease. I indicated it in the declarations starting from 2018. And I don't believe this actually being of great importance. I think it is a formality.
Didn't provide the answer to the question before when we asked you. We didn't receive the written answer to the question. So now we would like to know more. Yes, what was the reason and the purpose of obtaining a land plot for lease? So it was my question put to you because you are not very open with AG questions. But you know the situation is still unclear because in your annual declaration for 2024. You indicate the right of joint partial ownership, half share, of a residential building with a total area of 336 quadrat meter in Kropivnicki. The date of acquisition of the right is 27 December 2017. The other share belongs to your son on the right of joint partial ownership. However, according to our information back in December 2016, you donated 1/2 share of the above property to your son. How you can explain it? And then, did you really donate 1/2 of the above property to your son? If you have donated your share, why do you declare the right of joint partial ownership of a residential building after donating your part? Why did you not provide a copy of the gift agreement at our request? So those are the questions because you are not cooperated with the AGE and we have a lot of doubts concerning the situation. Please answer the question.
Я
I can provide more explanations once the broadcasting is cut because this matter is related to my son and I don't have his agreement and his confirmation on information to be disclosed. I got your point. I would kindly ask you not to interrupt me. I will provide you more details during the closed session. What I can say now, it is true that the house was purchased by myself in the interest of my son when he was a child. That was something that we decided inside the family jointly with my parents and with my husband, the father of my son. But when my son grew up, he said that he was assigned as the owner of this house without his consent, and he doesn't believe himself to be the owner of this house. However, it is true that we co-owned the house, but then right before war we decided to sell the house, and that is why we decided to re-register, to change, basically to make sure that the house has only one owner, because it is more convenient for potential purchase, and we had a specific purchaser at the time, and he wanted to get into the transaction with one person only. But then the war started, and everything was suspended. Besides, there were some issues with the electricity supply. I bought an electric car, and I wanted better to make sure that we have more powerful electricity supply. And when making the necessary arrangements, I found out that something happened during the registration of the deed of gift, and it was not reflected in the register. So that is why I decided that it was better for me to mention this house in my declaration, because obviously there was some mistake committed at the moment of registration of the deed of gift. What about speaking about the land plot? So one half of the land plot is still under contract of lease for the moment.
Copy of the gift agreement when we requested it as a AG. So now,
I don't have it. The current owner keeps the document.
No, yes, but when we it was earlier, so probably there was possibility to find it, but you didn't do it. Now we are going to the next question concerning your professional activity.
Dear Hannah, I disagree. I had no right to provide it. According to current legislation, that is my property.
No, it is very unclear. So when you would like to know how is exactly the state of the situation, it's better for us to have documents. If not, then exactly we have to ask you. And then now is the interview when you would like to know something more, yes, to have a clear vision of the situation. And now we are going to the next question. The next question, as I said, is concerning your professional activity. On 10th of July 2006, you received a certificate of the right to practice law. At the same time, in your declaration for the period from 2018 to 2024, you do not declare membership in the National Bar Association of Ukraine. Why did you not indicate information about membership in the National Bar Association of Ukraine in your declaration? Why didn't you answer this question earlier? It is still the same situation. We asked you for the question we put before, and you didn't cooperate with us. Please.
Dear Hannah, dear members of the AG, I have received my lawyer's license in 1996, and since 1996 till 2006, my practice of law was actually, I was practicing law, and this lawyer's license is the certificate I received again because of the fact that the previous was lost. I suspended my practice of law because I was working in the local self-governance body. And there was an unfortunate situation. This lawyer's license was lost, and I received another one that you can see it in the copy that it's with a hyphen. So the decision is made to grant me the lawyer's license in 1996. Regarding the declaration, I don't know. I cannot explain. I did not hide this fact, and even in the when rectifying information, I was trying to tick this box, but I wasn't able to do so. I do not hide this information. Why I cannot tick this box, and I cannot explain why it is not reflected, because I entered this information and for some technical reason I was unable to do so. That is not any concealment or any misguiding or misrepresentation of the facts. The declaration of the candidate that I filled in and of course, if elected, I will be able to approach the technical specialists who can help me to do this.
Yes, but we also ask you for more information about your independent professional activity as a lawyer. And we ask you in how many court cases in the period from 2024 to 2025 did you provide your service on a paid basis? What is the average cost of your legal service? Have you declared all income received from engaging in independent professional activities in the period from 2024 to 2025? Why didn't you provide us with answer to these questions? As you see, we have always a lack of information, a lack of answer coming from you. So please, maybe you are able to answer the question now.
Dear Hannah, dear members of the AGE, to the best of my knowledge, all lawyers, you're lawyers, but some of you lawyers who work in Ukraine, and some of you are international members of the AG, and according to the law on the bar, I gave my oath, and my contracts contain the lawyer-client secrecy, and all the income is declared, indicated in the declarations, and regarding the average cost, there are no costs. Some services are provided formally, and some might be free of charge because there are the ones that I paid the taxes, and my assistant also paid the taxes, and they had to rent an office. That is all properly declared. I cannot understand why you didn't understand it. The question was unclear to me because the declaration was submitted for 2024, and for 2025 I provided additional information, and maybe you didn't see this information. I attached all the income for 2025 from practice of law and from entrepreneurial activity. Regarding taxation and regarding the declaration of assets, my entrepreneurial activity as a private entrepreneur, that is only the provision of legal services. That is also the practice of law, and declared part as the entrepreneurial activity, and the declarations on the practice of law. And the declarations have been submitted, and there are amounts indicated there that are quite substantial.
I have no question in this case.
Дякую. Наталія Вікторівна.
Dear Natalia, next questions will be related to the land plot in a village of Pogrebi and a loan from your son. I'd like to close this information. Just let us have this technical So now we continue with the broadcast because those questions will be related only to you. Dear Hanna, please.
Yes, just a second. Now I am on. The question concerns your academic dishonesty. In May 2006, you defended your philosophy doctor thesis on the topic legal integration of Ukraine into the European Union, theoretical and legal research, and received the degree of candidate of legal sciences. In the course of the analysis of the text of this dissertation, the advisory group of experts identified a number of fragments containing borrowing significant volumes of text without proper reference to primary sources. In particular, the use of provisions from the scientific works of Kern's Introduction to the Law of the European Union and Topornin European Law, which are included in the list of used sources, but the corresponding textual borrowings in the dissertations are not accompanied by proper biographical references, and in some cases are reproduced almost verbatim. Do you confirm that the text of your dissertations, research for the degree of candidate of legal sciences, and the abstract for this research were prepared by you personally? And do you agree that when writing your dissertation research, you did not comply with the requirements of academic integrity? You allowed academic pluralism, in particular in the form of using information from the source without reference to the source, and verbatim, as I said, borrowing from the text. Please explain the situation.
Шановні члени дорадчої групи.
Esteemed members of the AG, esteemed Ms. Hanna, I've heard two questions and I will respond them one by one. It was me who drafted the dissertation and the abstract. It was 20 years ago, but I still disagree with your opinion on my lack of academic integrity. I mentioned that in my written explanation, so I reject the accusations of the lack of academic integrity, and I reject the accusation of the lack of cooperation from my side on this matter. I provided my explanations. I provided references to the then existing legislation, and besides, right before the interview, my academic supervisor would contact me, and I shared your opinion on the lack of academic integrity, of my academic integrity, with him. So we made parallels with the orthographic rules. The orthographic rules in the Ukrainian language have been changed recently. So if you take my paperworks and my tests from school, you may identify some mistakes if you check it against the current orthographic rules. But I don't think that it would be a good approach. Now, speaking of the plagiarism, alleged plagiarism, I contacted some acquaintance who works with the software and who knows the software which is currently used for plagiarism check, and he confirmed that none of the license or non-license contemporary softwares can be used in order to check for plagiarism, a work which was drafted 20 years ago. Besides, my work was referred to by other researchers, by other academia more than 60 times. In the light of the above, I reject the allegations of me lacking academic integrity because current rules and current approaches to the check for plagiarism cannot apply to something which was drafted 20 years ago. Besides, the legislation does not have retroactive, is not supposed to have retroactive application. I understand that this rule is not applicable to the approach of the advisory group of experts because you have to look into my past as far as my childhood maybe, and I'm supposed to be compliant with the standards of integrity. Besides, coming back to my dissertation, when defending my thesis, I had to face quite I was challenged a lot by my opponents during my defense of my thesis. I was asked multiple questions and I struggled through the defense session. And besides, I mentioned that, in my opinion, Ukraine should have go to the European Union path and the NATO path, and I was very much criticized by that. So it was really difficult for me to actually defend this thesis.
So I have no more questions in this case.
Дозвольте, я уточню. Тобто,
Can I clarify something with you? So, when back in 2006 you take an extract from somebody else's text and you reproduce it in full, verbatim, in your work without making reference to the source, without indicating something like esteemed researcher Kearns mentioned, it is compliant with the principle of academic integrity which were in place at that time. I think it was sufficient for me to mention the authors in the list of sources. So copying texts is okay. It was not about copying. It was about borrowing and paraphrasing. Why wouldn't you indicate the actual authors? At that time, I believed it to be acceptable. I indicated the authors and the respective sources in the list of sources used. Maybe I was not sufficiently aware at the time. And in my conversation with my academic supervisor, which I just had some time ago, I said that I was relying on my reviewers. I was relying on the fact that I would have opponents during the defense session. Besides, at that time, there was no possibility to have access to such a variety of sources. Thank you. We got your point. Thank you very much. There is yet another block of questions regarding bringing to administrative liability. I would like to specify something. In your questionnaire of a candidate for the position of a judge of the Constitutional Court of Ukraine to the questions whether you have been ever been brought to administrative liability, you mentioned that you have been not. And at the same time, in 2024, 2025, more than 10 decisions were issued in your respect regarding administrative liability. So I will not argue now whether these facts are important or not, whether you consider that these facts to be petty or not. But my question is, why wouldn't you mention this clearly in your responses? Well, actually, in my responses, I said that there were no court rulings in my respect on bringing me to administrative liability. Besides, I explained that as a lawyer, I would bear in mind the code on administrative offenses. So, as a lawyer, I have doubts regarding reliability of these automatic cameras, because they are not. These cameras are not properly licensed. That is why I don't believe them to be a reliable ground for bringing drivers to disciplinary liability. I have a speed limit control on my car, and I always try to comply with the traffic rules and control the speed. However, when it comes to this auto recording by these cameras, it is easier to pay 160 hryvnias of a fine than to challenge them in court, because the court fee is over 1,000 hryvnias. So from the financial standpoint, it is not even relevant. It doesn't make sense to go in court and to try to challenge these fines. That is why I would just pay those fines and forget about it. I indicated that I've never caused a traffic accident. I've never injured anybody while driving. I was never committing any other actions which would have negative impact on other drivers or other individuals. So as I told you, I would just pay those fines and forget about them, because I consider them to be non-important. But in the meantime, you have enforcement proceedings pending, including for the failure to pay fines. There are no enforcement proceedings payment. All the fines have been paid. It has been done automatically. And as of now, there is no pending enforcement proceedings in my respect. So you believe yourself as not being brought to disciplinary liability, administrative liability. That is why that you didn't indicate it. I mentioned that there was no court ruling in my respect. We wouldn't ask about court rulings. We were asking about administrative liability. I considered the fines to be the amounts of fines to be small enough not to mention them. Dear colleagues, do you have any questions to the candidate, Mr. Vasil? I have the following question to you. Who was your opponent when you defended your dissertation? If I'm not mistaken, Kostenko and Kozlov, or Mr. Kozlov or Mr. Kozlovsky? Kostenko who? Mr. Kostenko, are we talking about Mr. Kostenko, who is currently working in the Institute of State and Law? I don't know where did he work in the time where he was your opponent. In Taras Shevchenko National University, if I'm not mistaken. Who was your academic supervisor? It was Mr. Volodymyr Shelenhov. Yes, I know him. Yes, it's true. Where did you study? Where did you defend your thesis? I did it at the National Academy of Interior Affairs. At that time, it was the Institute of Interior Affairs. Who was head of department at that time? Mr. Husarev. Okay, thank you very much. Dear colleagues, do you have any additional questions to the candidates? If you have no questions, dear colleagues, Ms. Siur, you can deliver your closing remarks of up to 5 minutes.
I prepared a speech, but I cannot find it. So I will not be speaking long because it's already taking a lot of time. I felt this even when I was corresponding with the AG, partial attitude towards me. This bias, I even felt it in the correspondence that there were these questions, and the questions that were asked, I'd like to explain to the AG that I considered them to be provocation, and these provocative questions, because the way that they were phrased, the way they were forwarded, and those very questions, by the mere existence of those questions and the mere wording, it showed bias towards me. I was even surprised how I can be asked questions to provide this information from legal professionals like you. I was looking for the legal grounds, what to make a reference to. In particular, I'd like to draw your attention to the fact that, with all due respect to the AG and to, as it's set out in the Constitutional Court, the rules of procedure of the AG do not have the power of a legal framework. It's not registered in the MOJ, and it's not generally mandatory. It's not binding for everyone. Therefore, I have this conflict of laws to provide information to the AG, at the same time to break the client attorney privilege, the notarized privilege to disclose personal data, and to provide information without the consent of other persons. So had I provided this information, there would be even more questions as to my competence than not to provide it. And I considered, and I answered to you, esteemed members of the AGE, that I provided a respective consent, and I am sure that the check that had been very thorough and meticulous concerning me, and the NABU provided all the information on me, and no, I cannot not believe these sources, and you trust them too. I was surprised at this is confirmed. The constitutional rights of the nationals of Ukraine are not protected, and I am now convinced that this information that is collected in violation of the current legislation. Therefore, the Ministry of Justice provided information to you. As for me, when we work as the defenders of the rights in Ukraine, we have problems because there is abuse on the part of state authorities, because on the one hand there should be transparency, and on the other hand, esteemed members of the AG, I view this as the fact that candidates are victimized, and the judges are victimized by such demonstrative and frank circumstances of their private life, property issues, those matters must be protected. In Ukraine, war had been going on. I felt it even in my own case, how this can be abused. Because as soon as some information becomes public, judges are not defended and protected, the academicians, the military, because there should be protection of the personal data of the persons and information about them, and even the questions. I was surprised at how such esteemed NGOs that provided opinions regarding me, I disagree with it, and I ask the AG to have a look at those opinions, because had those NGOs been there, the information, such inside information was gathered that was even written, as they say in Ukraine, they literally wrote this on the fences. They were took some personal action regarding me. At a given point, I occupied certain positions, and I submitted my candidacy to the president through the system elevator, but even this, there are allegations that I have reputational risks and going to court to defend my rights regarding me. It wasn't a corporate conflict, it was plunder, it was hostile takeover, and together with the family, we have been through very trying times, and this criminalized group, I gave press conferences, and this is not reflected by the NGOs that provided their opinions and reports on me. I gave open interviews in horrible times. So when Ukraine, the direct radio, Freedom Radio, Svoboda, also I gave open press conferences on the defense of the rights that were violated, but that is not reflected in the opinion of the NGO and the international criminalized groups that worked in Ukraine and unfortunately continue to work. And I see it right now because the head of the SBU in Kirovohrad region chaired the SBU in Kharkiv region, and I approached the persons who were criminals, who were getting ready for the occupation of central Crimea. I was not defended, but as a defender of the rights, I was fighting it one-on-one through courts, through going to the in constitutional manner, through going to courts. I proved to myself and to people around me that in a state of law, first and foremost, the law should be the tool that should be used. And in all my life, not only on one, I'm not ashamed of anything that I've done in my life. Whatever I do, I consider that this is only the manner that a normal citizen and national in Ukraine should behave. Of course, to a priori answer questions that tell you lack integrity, I feel such bias towards me. I hope that through my sincerity and simple language, although I prepared answers, I was able to convince you that I am the one that has integrity, open, dignified person. And regarding my professional activity and regarding the fact that the Constitutional Court of Ukraine, as for me today, needs practical and experienced persons, because today I would like to criticize the last decision of the Constitutional Court of Ukraine. That is a bright example when the norm of the law on Ukraine and the public prosecutor's office is found unconstitutional, but has been suspended till the 1st January 2027. And I take part in those cases. It is incompetent suits by the office of the prosecutor, and this has very significant practical repercussions. So regarding this, I'd like to say that I'm convinced that I will be able, if admitted to participation in the competition, I will be able to prove my competence in further written competition. Thank you. Dear Natalia, we thank you for your answers. Dear colleagues, dear public, I hereby declare closed the